Next matter to come before the court is State of Ohio versus Nelson Ocasio.
May I proceed, Your Honor?
Please.
Thank you.
You will have 15 minutes to present oral argument. Please let me know if you wish to reserve any time.
Thank you very much. Your Honors, may it please the court, my name is Robert Dixon. It is my great privilege to appear this morning as appointed counsel, appellate counsel for Nelson Ocasio, appear before this honorable court. If I would, I'd like to reserve 5 minutes of my time for purposes of rebuttal. Your Honor, if I may just say at the outset as a preface, if you will, these are perhaps the most difficult cases faced by the court, defense attorney, even prosecutors, and probably appellate courts. The stakes are high on both sides. You have Mr. Ocasio, who this morning continues to serve a life sentence. And you have, if allegations are true, a 7-year-old child who was a victim of the offense, if the allegations are true. Your Honors, I asked the court to briefly allow me to go into the facts. I know the court has read the briefs carefully. The facts are fairly simple, though. The 7-year-old child, who we'll refer to, and we have in the briefs as JB, indicated that one day after she'd gone to church with her family, she was playing in the area of her apartment. A man that she knows from the apartment area, a neighbor they call Poppy, the appellant, Nelson Ocasio, had conversation with her, and then at some point she ended up inside his apartment, which from the record it appears that may not have been entirely unusual that she was out walking around and engaged neighbors in this way. But at some point she indicated that while in the apartment and on Mr. Ocasio's couch, that he reached in with his hand into her pants and touched her on the area of what she referred to as a 7-year-old as her ladybug. After questioning by the prosecutor, and we would suggest somewhat leading questioning, she indicated finally that not only did he touch her in that area, but that he touched her inside the ladybug. Hence, that is the evidence, and I think the total evidence that was presented of the supporting the charge of rape and gross sexual imposition. He was charged in 2 counts. Count 1 was rape, the second count was gross sexual imposition. She then left, went home. He went with her, and he said to her, the mother, "You need to talk to your daughter about something." And at that point, there was some discussion, and she said, "He touched me inappropriately," essentially. At that point, her uncle punched Mr. Ocasio, and the police were called. The young lady, the 7-year-old JB, was taken for a medical evaluation by a sane nurse, and I think it's fair to say that there was no corroboration from a medical standpoint or anything else that the sane nurse could testify to corroborate the allegation. So again, Mr. Ocasio serves a life sentence based on essentially those very few words that were elicited, that he touched me inside my ladybug. Your Honors, the issue that is most concern to us, and I'd like to discuss briefly with the court, is issue number 2 regarding the competency of this child. And that goes back to, I think, the whole essence of this prosecution, since it was a case, really a one-witness case, without any corroboration of a physical nature or otherwise, I would suggest. As we stated on page 10 of our brief, assignment error number 2, we believe that the court erred and abused its discretion in finding the 7-year-old competent. We set forth for you the case of State versus Frazier, which I think is the controlling law in the state of Ohio. The Supreme Court asked the court to consider 5 factors. And again, the court does not, I don't think there's a requirement the court has to enumerate each and every one of those as it does. And again, it is an abuse of discretion standard that this court must apply to the court's findings. But I think that on balance and giving a fair reading to the competency hearing and also to her later testimony, I think it's fair to say that the court did abuse its discretion in finding this 7-year-old competent. True enough, during the competency hearing, she recited answers to the questions, you know the truth, the difference between truth and a lie, kind of standard questions that we've all seen probably, and she did do those.
Yeah, she successfully identified a truthful answer and a deceitful answer.
She did, Your Honor.
Subjectively demonstrating at least enough understanding to make the correct answer.
I would agree, Your Honor. I won't disagree with that was the testimony of the competency hearing. But I think that the court needs to look at all the testimony. What happened when we were sort of in the other part of the trial and we were not in the strict confines of a competency hearing with simple questions like that. I think at times that the testimony of the 7-year-old, even for a 7-year-old, was highly unusual at some point. And we pointed some of those out in the statement of facts to you. At times she was quite flippant for a 7-year-old. She indicated that she likes to be the center of attention. She said some bizarre kind of things that when people were laughing, she said the word sushi. And then she said, I said sushi because you were all laughing. And just things that were almost nonsensical, even for a 7-year-old. In the context of a serious criminal case, we suggest those are the kind of things that the court should have perhaps revisited its earlier decision. Merely because the court found her competent in the confines of that very brief, what I would say very brief competency hearing, I don't think relieves the court of the ultimate responsibility under the statute to ensure that witnesses are competent and testify.
Was this matter addressed to the court during or after the testimony of this witness? Was there the motion renewed based on the testimony?
It was not. It was not. And I would argue in really two regards here, to your honors. Either asking the court to consider it as plain error, or in the alternative, that the court ruled that the trial court itself has a responsibility in dealing with children under the age of 10 to at all times ensure that competent testimony is placed before that jury. So we would argue under either scenario that this court has the ability to entertain this issue. But it is true that the court or the defense counsel did not re-raise the issue of competency. Your honors, if I may, very briefly, I want to touch on also one other issue that I think is of concern, especially in a case where it was essentially a one witness case. The state's case rose or fell on the testimony of the 7-year-old, and that is issue number 3 on page 11 of our brief, where we've alleged that the prosecutor impermissibly vouched for this witness. Let me say first, I have ultimate respect for this prosecutor. I've tried cases against him years ago, and he's a very good prosecutor, extremely skilled, no question about it, and he's a man of integrity. So I don't mean to say in any way that professionally he is not. However, I think that in this case, he did impermissibly vouch for this young witness during his closing argument when he referred to her as he said something to the effect that this brave 7-year-old came in here and told you the horrible things that happened to her. I think when he says the word brave, that's not commenting on her credibility. He could have, I think, argued she was a credible 7-year-old. He could have argued a lot of things about her testimony, but to say that she was a, quote, brave 7-year-old, I think is impermissibly vouching for her and suggesting to the jury that something that's simply not in evidence and that's something that they probably shouldn't consider. We cited to you U.S. versus Severide, and in that case there also was no objection as in that there was not in this case as well. So again, we're asking the court to consider this under the plain error doctrine, unfortunately. In Severide, the prosecutor, it was kind of a similar one-witness type case where the police officer was the sole witness, and the prosecutor in that case referred to him as a good, honest cop. The court there recognized it as plain error. The court recognized that in a sort of one-witness case where the state's case rose or fell on the testimony of that one witness, that it was an extremely significant comment. We would argue the same.
May I stop you for
Yes,
just a
Your Honor.
moment to let you know that you have now reached your 5 minutes.
Okay.
If you wish to proceed, you may.
No, just with that, I would thank the court for your time and consideration. Thank you.
May it please the court, my name is Elizabeth Lindberg, and I represent Appellee the State of Ohio. I won't go into all of the facts, as you said, you've read the briefs. However, in May 2013, Appellant Nelson Ocasio raped and perpetrated a gross sexual imposition against a vulnerable 5-year-old victim. For these crimes, he was indicted with 1 count of rape in violation of Ohio Revised Code Section 2907.02A1B, and with a repeat violent offender specification, and 1 count of gross sexual imposition in violation of Ohio Revised Code Section 2907.05A4, felony of the 3rd degree. Following a jury trial that concluded on January 30th, 2015, where a jury of Ocasio's peers found him guilty of both counts, trial court sentenced Mr. Ocasio on March 20th, 2015 to 15 years to life in prison on count 1, as the victim was under the age of 10, no additional sentence on the repeat violent offender specification, and no sentence on count 2 as it merged with count 1. Ocasio was further labeled a Tier 3 sex offender. I'll just go in order of assignments of error. In the first assignment of error, Mr. Ocasio claims that the trial court committed plain error by failing to instruct on a mens rea for both offenses of rape and gross sexual imposition. In this case, obviously, Ohio Revised Code 2901.21b states that when the language defining an offense does not specify any degree of culpability and plainly indicates a purpose to impose strict liability for the conduct described in the section, then culpability is not required for a person to be guilty of the offense. The first count in this case is rape, which is a strict liability offense. There's no mens rea provided for. The offender's mental state and the victim's consent are immaterial when the victim of the rape is under the age of 13. In this case, when the rape was perpetrated, she was 5 years old. Secondly, to the issue of gross sexual imposition. Again, gross sexual imposition of a victim under the age of 13 is a strict liability offense. However, for the issue of if the gross sexual imposition was perpetrated for the purpose of sexual arousal or gratification of the offender must be shown. Mr. Ocasio cited to State versus Dunlap, 129 Ohio State 3D 461, stating that a definition of purpose should have been included in the jury instructions. In that case, however, the jury instructions, first the indictment provided sexual contact within its language, did not define purpose, and in the jury instructions, sexual contact was defined, which included the word purpose. However, it did not, again, define purpose. In that case, it says the indictment tracked the language of the charged offenses, and the trial court properly instructed the jury on the element of sexual contact. In its conclusion, the Ohio Supreme Court stated, behold instead that the element of sexual contact in an RC 2907.05A4 violation requires mens rea purpose. However, since we conclude that the indictment and jury instructions in this case sufficiently set forth the required mens rea, we affirm that portion of the Court of Appeals judgment.
What was the, Mr. Ocasio did not testify on his own behalf, is that correct?
That is correct.
Were there any defense witnesses?
No, there were not.
And so, what are we going to find in the record regarding opening and closing, if anything, regarding the defense? Was it just, was it limited to the lack of proof on behalf of the state?
That is how appellee would view it, yes, Your Honor, that it was based largely upon the fact that there was a 7-year-old testifying. That was the only direct testimony of exactly what happened. And therefore, for those purposes, and because of, I believe, how she was on the stand and the jury being able to view her claiming that, and repeatedly claiming that she was lying while she was testifying. So it is the state's belief that that was Mr. Ocasio's claim at the trial court level.
And I raise that in the context of your argument regarding the mens rea, because depending on how a case is presented, I could foresee a defense under certain circumstances of, well, perhaps something happened, but it was accidental, it was not intentional. For example, a relative bathing a child or something.
Correct.
But under the circumstances that this young child testified to, apparently that was not reasonable to.
That is correct, Your Honor. It was not someone who was a relative who may have been bathing her or changing a diaper. I mean, 5 years old is probably too old, but under that concept of maybe it was an accident, that factually would not have been the situation we encountered here. This court in State versus Edwards in 2013 again addressed the issue of failing to define purpose in the jury instructions, and that in that case it did not rise to the level of plain error. This court wrote, a defendant's purpose may be inferred from the type, nature, and circumstances of the contact, along with the personality of the defendant. In that case, the victim testified that the defendant touched her below her clothes, on her breast, and vaginal area. And because the record didn't indicate any other rational explanation for the sexual contact that occurred, it was sufficient without having defined purpose and did not rise to the level of plain error. That is a very similar case to what we have here. There was no definition of purpose. However, based upon all of the facts laid out, being that the victim testified that Mr. Ocasio touched her with a bad touch, that their skin touched, he touched inside her clothes, inside her underwear, and inside her ladybug, and it hurt. She told Mr. Ocasio to stop twice, and he did after a second time, that his relatives were not there, that Mr. Ocasio went to the victim's mother and disclosed that she had told him that she had been touched, and then that the victim told her mother that Ocasio told her not to tell anyone, that touching could not be viewed as a touching for any other reason than sexual gratification or arousal.
So, I want to make sure I understand. The testimony was that when she returned home, he was with her, and that he said to her mother, "You need to speak to your daughter."
Yes.
And it was at that point, in his presence, that she said that she had been touched inappropriately, and that he did it.
Correct. I believe the victim had gone into a bathroom, had walked into another room, and her mother went there and asked her, and that's when they had their conversation. I believe Mr. Ocasio was in the kitchen when he told the mother that you need to speak to your daughter.
And so, was there testimony that he denied this, or this is just when he was punched?
I believe this is when he was punched. I'm not sure that there was any interaction as far as a denial.
And then the police were called?
Correct. Moreover, even if it had been an issue that there was no definition of purpose, Mr. Ocasio was not sentenced on the GSI count as it merged with the rape count, and therefore failing to define purpose would not, it would inevitably be be harmless error. As to assignment of error 2, and Mr. Ocasio and his counsel claiming that the trial court abused its discretion in finding the victim, 7 years old at this time, incompetent to testify at trial. We all know the elements of State v. Frazier. Specifically, in his brief, Mr. Ocasio relies upon the court not making a finding as to the 5th prong, which is the child's appreciation of his or her responsibility to tell the truth. The trial court is given wide latitude to determine if a witness is competent to testify. The trial judge was the one who viewed her responses to questions and her subsequent testimony, so he would be in the best position to be able to judge whether or not she was competent to testify. The competency hearing, I believe, was about 17 pages of a transcript, so I'm not sure that the state would consider that brief. However, she did say during a competency hearing that it's bad to tell a lie, it's good to tell the truth. The court said if you talk to anybody else here during this time, your time here, are you going to tell the truth? She responded yes. And then she told the court again she was going to tell the truth when she was sworn in, and the state asked at the beginning of direct examination, what are the 2 most important things for you to do today? Number 1 is what? Her response, tell the truth. She repeatedly recognized that it was her responsibility to tell the truth. Again, as Judge Whitmore mentioned, in her competency hearing, she was repeatedly able to differentiate between the truth and a lie. She subjectively knew the difference between the two. And all of the prongs in Frazier were met. It is believed, though, that the state believes that trial counsel did renew the objection to having the victim's testimony and finding her competent. I believe it was at the very conclusion of the competency hearing, and she had filed a motion to that effect. It, however, was not renewed at the end of her testimony in court. As to assignment of error 3, that the appellant was denied due process of law because of prosecutorial misconduct. Again, this issue would have been forfeited because it was not raised and not objected to during the actual closing argument. The main thing that's relied upon at this juncture is the statement, this brave 7-year-old got up on the witness stand and told you about a horrible event that happened to her. Importantly, the assistant prosecutor did not discuss the victim's truthfulness. It was a rebuttal closing, so the assistant prosecutor was responding after trial counsel repeatedly stated that there were lies and attacking the victim's veracity and version of events. It was even if it were to rise to the level of the good, honest cop statement that counsel now refers to, which the state does not believe that it rises to that level, it is only one isolated comment in the context of an entire closing, an entire trial, the evidence of the 3 witnesses, or the testimony of the 3 witnesses that was presented. And the court twice told the jury that the closing arguments were not evidence. So the jury would have been aware of that even upon hearing that one statement. Moreover, in light of the fact that the state does not believe that the comments were improper, but if the court were to determine that were the case, it was not prejudicial enough to impact the outcome. The state presented testimony of the victim's mother, the SANE nurse, they all testified, the jury viewed the testimony and clearly determined that it was credible and rendered a guilty verdict on that basis. The assistant prosecutor also discussed the strict liability nature of the offenses, and again, both of the offenses are strict liability crimes. And him stating that to the jury was not a misstatement of the law, it was an accurate recitation of the law. Again, although he did not include a definition of purpose, purpose would have been able to be reached by the jury by the nature and circumstances of the contact and all the testimony that was presented. Finally, again, because there was no sentence rendered on the gross sexual imposition count, any error found describing it as a strict liability crime is harmless error. To the 4th assignment of error, the verdict and judgment was against the manifest weight of the evidence. Specifically, this court should reverse convictions only for most exceptional case in which the evidence weighs heavily against conviction. That is not the case here. As discussed previously, because of all of the individual things that were said by the victim about a bad touch, being touched inside her ladybug, telling him to stop, and Mr. Ocasio's relatives not being there and taking her into his apartment. Because of all of this, that is the testimony that was presented. All of that information that was presented to the jury cannot be overcome based upon their verdict by the cross-examination that was done during the trial and whatever doubt that may have elicited. In the brief, counsel relies on what he deems equivocal statements about penetration. However, she said in the transcript at 156 to 57 and 160 to 61 that she was touched inside her clothes, inside her underwear, and did say she was touched inside of her ladybug and that it hurt.
And you have reached the end of your time.
Thank you very much. For the foregoing reasons, appellee requests that this court overrule each of Mr. Ocasio's assignments of error and affirm his conviction and sentence. Thank you.
You're welcome. Mr. Dixon, you have 5 minutes remaining.
Thank you. I don't think I'll use all of it unless the court has questions. I just would like to, if I may, briefly, on the issue of competency, indicate that I believe that Frazier, State versus Frazier, rules of evidence and the Ohio statutes, and then when you have a case dealing with a child under 10, that there is an independent duty upon the trial court to ensure that witnesses are competent that are testifying to a jury in a serious felony case. And so I think that while the issue was raised pre-trial properly by counsel, I don't think they even needed to. The court would have had to make the same inquiry anyway. Similarly, I think that while counsel at the end of the hearing disagreed with the court's findings and did not renew it later, I don't believe that that was necessary either. I think that the duty upon the trial court is continuing. And I would just implore this court to look carefully at some of that trial testimony that we've set forth on page 3 of our brief. So unless there's any other questions, I thank the court again for your time.
Thank you. Thank you both for your presentations. The court will take the matter under advisement. We will issue our ruling and we'll send it to both sides. Do check the Supreme Court website as well. Have a good day.